Welcome back to Law and Crime, and we were just hearing opening statement by prosecution. This is in the Stanley Liggins case. This was a crime committed in 1990, and it involved the strangulation, sexual abuse, and murder of a 9-year-old child. I'd like to introduce at this time, very happy to have with us today, trial attorney Michel Bryant.
Hello,
welcome.
How are you?
Good to see you. Thank you for being with us today.
Bet.
So talk to us a little bit about 1990. That's when this crime was committed. There have been 2 convictions on these charges since that time. We're on number 3. 28 years later, how hard is the prosecution going to have to work to prove this case?
Oh, my gosh. I remember 1990, barely. Yeah, I mean, this is a situation that is very unusual in that the 2 reversals, both from the 93 conviction and the 95 conviction, were based on technicalities really not having anything to do with the facts of the case. Nobody's disputing certain facts. It was other technicalities that I'm sure we'll get into in some detail. But as we understand this case and the evidence that's going to be presented, there's not a lot there. It's a lot about the defendant, Mr. Liggins, being in a proximity to the ultimate victim and having some knowledge and contact with her prior to the murder. That's the case, and so that is always a tough case. Right,
so it's going to be all circumstantial evidence. It's going to be really interesting to see how the prosecution proves all of that from 28 years ago. Now, the other thing we want to mention is that the defense, did reserve opening statement. Now, what does that mean, Michael, in your experience? Why would they possibly reserve?
Yeah, and first of all, the opening statement by the prosecution was pretty darn tight, you know, for a case of this magnitude. But the reason is generally because they're going to make a motion to dismiss at the end of the prosecution's case. Not unusual. Even if the defense had given an opening statement, they probably still would have made that motion. But this allows them to put in their opening statement followed immediately by their evidence.
Okay, so I'm smiling because on break we were talking about it, said, oh, here we come. So we're going to get a motion to dismiss. All right, we're going to return to the courtroom now to see what evidence is being presented. So we are still covering the trial of Stanley Liggins, an Iowa case in which he is accused of murder and other crimes against a 9-year-old child. And as promised, the prosecution is presenting right now its first witness. His name is Michel Bryant, and he is testifying as to the fact that he saw a fire on school grounds. With me, Michel Bryant, I'd like to ask you on this case, so how effective is it to have a witness from 28 years ago? How does that affect the credibility of that testimony?
Well, you know, like any witness, the jury's going to get to figure that out. You know, this guy seems to be, you know, hey, he was in Dad's club. I mean, come on. So he must be somewhat trustworthy. Those were the days, back in the 90s. So he was just there as part of a civic function, and he comes across as very credible and very honest and just like a regular guy. I think the jury can understand that, whether he's testifying about events 28 years ago or 28 days ago.
And how much do you think the fact that it occurred 28 years ago is actually going to be something that's going to cause him to not have the memory that he may need to give the facts as best as he can recall?
Yeah, there's no doubt on cross, every witness in this case is going to be pounded on that very fact. This guy is such a foundational witness. He's talking about where the school is, where he saw the fire. I'm not so sure there's a whole lot to chew on from a cross-exam perspective, but everybody, keep in mind, everybody is going to get just hammered on how long ago it's been.
Sure, absolutely. So when we next talk, we're going to visit about the fact that there have been 2 convictions in this case, and the jury specifically is not going to know that. They will know that there were 2 prior trials, but they will not know that there was a conviction in those cases. So we are going to take a break now, and I hope that you will stay tuned and join us when we return to the trial of Stanley Liggins. So that was the second witness that the prosecution presented, and it was the janitor who testified as to his actually seeing the body down an incline, and then he gave specific details like the tennis shoes on the child's body that he was the first to see and report. So again, Michael, let's talk about why are we trying this case 28 years later? What happened with the appeals in this case?
Yeah, that begs the question, what the hell happened the first 2 times?
Right.
Now that we're doing this the 3rd time. The first trial was not long after the crime took place in 1990. The conviction was 93. The appeal went up, and the claim was that Mr. Liggins had a history of some drug dealing that the jury was allowed to learn about. And obviously, that can be prejudicial, and that's what the appellate court decided. It was so prejudicial, in fact, that he couldn't get a fair trial. Okay. And so we go for round 2. Okay? Round 2 progresses. The first level of appeal fails, but the argument was the same, and that is that there were 77 police reports that were not provided to the defense. Now, you have to provide any exculpatory information to the defense. That's just the way it works.
Right.
They didn't do that. There was also a witness who allegedly had been a paid informant on about 80-some other cases, although not sure it was on this particular case. That was not disclosed. That was plenty for the Court of Appeal, not the first level of appeal, but ultimately it did bring us back where we are today after 2 guilty convictions.
Well, let me ask you about that. So when there's 77 documents that are not handed over like they're supposed to be, that's a fair reason that they would say, okay, nope, this is an overturned conviction. Would you agree?
Of course, and the prosecution says, hey, there was nothing in there anyway. They were just police reports, not much to do. You know, that's not your job, dude. It's the defense job to go through that and see whether or not there's something that can help the defendant.
Right, right. Another example, the prosecution doesn't get to decide the laws. All right, we're going to go. Are we going to a break at this point? We are going to a break at this point, and we'll be back. Please stay with us. So we've been following the Stanley Liggins trial out of Iowa, and it's a fascinating case because this occurred 28 years ago. There have been 2 appeals overturning convictions, and they are on a 15-minute break in court at this time. So we are going to listen to the top crime stories, and I hope you'll stay with us.
Here are today's top crime stories trending on Law&Crime.com and across the country. Investigators in Philadelphia are looking for a wrench-wielding madman who was caught on camera attacking a Wendy's employee and threatening to break a window with a socket wrench. The suspect can be seen on camera becoming upset after having issues placing his order at a Wendy's drive-thru. The suspect couldn't have it his way and lost his cool, banging on the drive-thru window before returning to his car to grab a socket wrench. The unidentified Hamburglar is still at large. Authorities in Pennsylvania arrested a suspect in the murder of a former Playboy model found dead in her apartment last week. 30-year-old Jonathan Wesley Harris was arrested after investigators received a tip after releasing this surveillance footage of the suspect. Harris is accused of killing 36-year-old Christina Carlin Kraft, who was found dead in her condo in Ardmore, the victim of an apparent strangulation. The one-time Playboy Playmate's body was discovered after police conducted a welfare check. Harris faces charges of first, second, and third-degree murder, as well as robbery and theft charges. Authorities have reportedly found the woman seen in this now viral video ringing the doorbell of a home while wearing broken wrist shackles and a t-shirt. Investigators will not release the 32-year-old woman's name since she is considered a family violence victim. Residents in the Sunrise Ranch area of Montgomery reportedly saw the woman ring several doorbells to no avail before fleeing. Authorities say the woman's boyfriend was found dead of a self-inflicted gunshot wound inside his home. Those were today's top crime stories. I'm Anthony Velez for Law & Crime.
So welcome back. Wow, let's talk about the story in Texas where she has broken shackles. She's been ringing multiple doors. One of it was caught on video, and it begs the question, what happened to her? Was she a victim, and that's why she had on a T-shirt and broken shackles? Had she been arrested? We just don't know the whole story yet. But, Michael, let me ask you, what would you do if she were ringing your doorbell?
You know, I would probably answer. I would, just because if you have the ability to assess this person, she doesn't appear to be a threat.
Okay.
You know, she looks more like a victim. Maybe that'd be a mistake ultimately, but that would be my gut reaction, to open the door and find out what the heck's going on here.
And do you think there's any way that we can tell from what we saw as to whether or not people were home and just ignoring her? Were they maybe not home and the video was coming on? Do you know anything about the videos that turn on and record?
You know, the Ring, I'm not doing a commercial for Ring, but they have a motion sensor, as most of these gadgets do. And so when she turned the corner around that little brick wall there, it would have triggered the motion sensor and begun recording. So you don't have to be home. You don't have to ring the bell for it to activate the video that we just saw.
Okay. So in either case, it's a tragic story because they do say they're not releasing her identity given she's a victim of family violence. The other piece of this story that we haven't yet heard more about is the fact that the person at her home, and I don't know if it was a boyfriend or a husband, I'm not quite certain, but that person apparently has died from a self-inflicted wound. So I think we're going to learn a lot more about this story as it develops and the breaking news. And we are going to now return to the prosecution's opening statements in the State versus Stanley Liggins. And you'll note, and as you listen to this, they're going to lay out the evidence that they intend to present to prove the murder charges and arson and kidnapping and sexual assault against Stanley Liggins. This is the prosecution's opening statement. For joining us on Law and Crime. It looks like in the case of Stanley Liggins, the defendant in the Iowa case accused of murdering a 9-year-old child, is returning. The jury is returning to the courtroom. So while we wait on their return, I'm going to ask Michael, our trial attorney, about what do you do? So what they say is in one of the prosecution's witnesses has now passed away. And so what happens? How do they present that testimony, and how effective is it?
Yeah, they have to qualify first as unavailable. Death is a pretty good unavailability. But there could be other reasons. There could be sickness. They're just unavailable for many reasons. If that's true, then you look at what the alternative is. And in this case, it's transcripts from prior proceedings. It's brutally boring. It's nothing like the give and take you might have between an attorney and a witness, and obviously there's no way to cross-examine the transcript. So whatever cross-examination was done in the lower court, or in this case the prior proceeding, you're stuck with that. And I guarantee you there have been discussions about what's going to be included, what isn't. I'm most interested in how they present it, because it's been done so many ways. Sometimes the clerk will play a part, one of the Q or the A, and then somebody else will play. So the more entertaining they could make it, the better it's going to be for this jury, the better it's going to sink in.
So if you were the attorney in this case, how much time would you spend actually reiterating some of that testimony from the transcript and giving it to the jury in closing argument to make sure they heard the relevant points instead of not hearing it because they were bored?
Exactly. Well, that's what you got to have. Just the relevant points. You got to be surgical. Go in there, chop it up, and make your points, but do not belabor it. Do not fill it with all of this connective garbage that really doesn't help you.
Right. So this is a case, again, it happened 28 years ago. So a lot of the evidence is going to be obviously somewhat stale in terms of it's the best they have. Recollections may have changed, may not have changed. Certainly the witnesses have been prepared by the prosecution and the defense, but we're going to see what happens as this trial continues to roll forward. Now, one of the other things that's important to know is both sides agreed, the prosecution and the defense, that the fact that there were two prior convictions is not going to be admitted at this trial. So the jurors are not going to know that. Michael, why do you think that was agreed to? What does that mean?
Well, they can't hide everything. They aren't going to dwell on the reason for this third trial, except that the other two didn't quite work out as they should have. They're leaving to the jury to speculate why.
Okay, so we're going to return to the trial now, and Stanley Liggins, let's see what their next testimony is. We have just heard from the prosecution's third witness in the case versus Stanley Liggins. This was Miss Scholes. She was Miss Ward in 1990. Again, that points out how long ago this crime actually occurred. And she is a 911 dispenser, and she did set forth her training and qualifications and then testified as to the call that she took, specifically stating that it was a trash fire by Jefferson School. Well, we now know it was not trash. It was actually the body of the 9-year-old who was found murdered after being brutally attacked and raped. Having said that, let's talk about one of the things is exhibit number 77 that was introduced, and that's a copy of the transcript. And why is it important, Michael, that they actually presented a transcript in this case when they already had her testimony?
Yeah, I mean, this is the 911 log, effectively. And so if you lay the proper foundation, this woman is also the custodian of records officially. And to do that, you have to contemporaneously write down what you're observing. It has to be part of the normal course and scope of the business. All these little, you may not cue into those things, but that's what the judge needs to hear before he says, yes, you can take that log and let the jury see it. And now they have in front of them the exact time that call came in.
And why do you, or is it even more important when this person was testifying about something that happened 28 years ago?
Oh, yeah. I mean, every cue that the jury can have that solidifies these facts is going to help the prosecution.
All right. So this is a fascinating case, given the current, that we're 28 years later, that there have been 2 appeals, 2 convictions overturned in this case. We're going to see what happens the third time around. We hope that you will absolutely stay with us. We're going to stay with this trial the rest of the afternoon. And right now we're going to take a short break, but please don't go away. Come back and listen to more of the trial with us. So we've just heard testimony from Captain the Davenport Fire Department, Captain David Perrick. I wanted to get his name correct, so I was looking at my notes. And interesting, he has been with that fire department for 33 years. So one of the things that I think is relevant in this trial is the size of the community. Here you have individuals who have been with the same fire department, for instance, for 33 years who just testified. You have prosecutors in this case who are actually brother and sister, which is not typical, I would submit. And the trial was moved to a different venue or different county because of the publicity concerns in this particular case. So let me ask you, do you think that the size of the community makes the difference in whether or not this defendant's going to have a fair trial?
No, of course, always. But in this case, I think it's magnified for the reasons you mentioned. I mean, I've driven down 80 between some of those quad cities. It's lovely, rolling hills with bales of hay on either side, but not a lot of bodies, not a lot of business, not a lot of activity. So these towns are 130 miles apart. It might as well be down the block, really, in terms of that way of life and in that concentration of people.
So when this happened in 1990, we know that he knew the family. We also know that he was in the area, that it's circumstantial evidence that he actually committed this murder. And he was out on bond for molesting, allegedly, another different 9-year-old girl. Do you think that this defendant's been railroaded in this case?
That's definitely what the defense is going to argue, that, hey, we found this guy, he fits the profile, he also knows the victim and the victim's family, he had interaction with the victim within hours of her being found burning and attacked and ultimately dead. So he's a great-looking suspect. Why go elsewhere?
All right, so we're going to stay tuned and see what happens. We're going to be returning to the trial of Stanley Liggins today. We hope that you will stay with us for this exciting trial. Right now, we're going to take a short break, and we'll be right back. So as you can see, something's going on in the courtroom that's just causing a delay in further testimony. It looked like perhaps a juror needed something. A Kleenex was passed over. So we are going to take a short break until the testimony resumes. One of the things we've been talking about on this break, and I've been talking with Michael about, jury composition. So we know in this particular trial that it is an African-American man who is charged with these crimes. On the jury, the composition of the jury, as we understand it, is 5 men and 9 women. Of the 5 men, 3 are African-American, 2 are white. And of the 9 women, we have 1 African-American and 8 white. So let me ask you, Michael, how does that affect, if it does, the fair trial in this case and the jury composition?
Well, you know, the jury of your peers, that's the phrase, that's the goal. So if that 4 out of 14, was it 4 or 5 out of 14?
5 out of 14.
5 out of 14, if that...
No, 4. I'm sorry, 4.
Okay.
We'll get it straight soon.
That sounds to me to be maybe a slight overrepresentation of that particular area in terms of demographics and racial breakdown. But that sounds reasonable. If there was 1, might raise an eyebrow, 2, maybe less so. 4 out of 14, and we should point out, it's not 14 jurors that will make a decision. We think at least they will hear it all the testimony, and then they'll whittle away at the alternates at the end. Yeah.
Okay, great. And so we are going to stay tuned. I hope that you'll stay with us for this trial. We're going to return to the trial or take a short break. Let me see if I can get a little guidance on what we're going to do next. So we are going to be taking a short break, but we are not going to be leaving this trial. So I hope that you will stay with us, and we will return to the trial of Stanley Liggins after we hear this short break. Thank you. So glad you're still tuning in to Law and Crime. If you're like me and I'm a trial nerd, I absolutely love watching these trials and seeing what's happening. We are currently watching the trial of the state of Iowa versus Stanley Liggins. We are going to return to the courtroom in just a minute, where we will hear continuing testimony in the reading of the transcript of the arson investigator from 1990. Now, there have been some photographs introduced, and it's my understanding they're going to introduce some more photographs of the actual scene. So we are going to return to court at this time to hear the 6th witness's testimony via a transcript reading. So at this point, we are not going to return to the courtroom, and I will explain why. For all of our viewers and listeners, there is a body being shown, and we are not allowed to show that, obviously, today. So we are, or at any time, we are going to continue with coverage, and let's talk to Michael about how do you think this case is going for the prosecution of this case, given we're on the 6th witness now?
Yeah, well, this is a lot of foundational stuff. We've now learned the location. We've learned the time, at least, of the reported fire. We've learned the response time for the fire department. And now we're just starting to get to really some of the grisly detail. I mean, now that we know it's not a grass fire, it's not a garbage fire, this was a human being, and the jury is starting to see what that really means. And, you know, may have had thoughts in their minds about what it means to see a burned body in a field. Now they're seeing the photos.
Right. And for those of us who cover trials frequently, I know that sometimes, unfortunately, we hear all too often the horrific crimes that are committed and the horrible murders that we cover. But again, this is a 9-year-old victim, and she was not just murdered, so to speak. She also was sexually abused, strangled, put in a plastic bag, and doused and lit on fire, according to the prosecution in this case. So it's really a horrific set of facts, terrible circumstances for this 9-year-old child and the family of this 9-year-old. One of the things that is fascinating in this case to me is that you have a defendant who has been in jail for 28 years. He's standing his third trial for this crime. You have all the same evidence. So, Michael, why is this not a waste of taxpayer money, and why do we have to do this yet again?
Well, you know, if you get it wrong the first 2 times, and that standard is determined by the appellate judges for the most part, then you've got a choice as a prosecutor. You either pursue the third trial to get some justice for the victim and the victim's family, or you say we can't do it. We've blown it twice. We can't do it. The reason I think this case is now being presented is something I mentioned earlier, which is that the facts were not the issue on either appeal. If there had been some problem with the facts, the underlying facts, that the prosecution was unable to connect the dots to get a jury to conviction, maybe we wouldn't be looking at a third trial. But when they were things involving, you know, collateral issues like the defendant selling drugs, that was trial 1 reversal, or the lack of the prosecutor providing reports they should have to the defense. Again, not factual issues. That's why we're in this third case. The facts still point to this defendant in the prosecution's mind. All
right. Thank you, Michael. So we're going to return to court. It will be audio only because of what's being shown, but we're going to rejoin again the reading of the transcript of the arson investigator of the Davenport Fire Department at this time. We're waiting for the testimony to resume, and again, you could see that we had noted that there was graphic content. There were pictures of the little girl's body that we could not show. Suffice it to say, very graphic pictures, and the body has been burned in those pictures. Michael, do we have any information that you know of about the cause of death and what that was in this particular case?
Yeah, it's my understanding, and this is somewhat comforting, that it was the strangulation that ended her life. So, you know, your mind starts to wonder, well, the body was burned, was she alive? And certainly we've seen that before. From what I understand, that was not the case in this situation, that the body was, it was a cover-up type arson.
And how, obviously the pictures can come into evidence. They're pictures of the body as it was found, but how prejudicial is that potentially to a jury? Because if you see these pictures, I promise you, you would convict probably anyone sitting in the defendant's chair, because they're absolutely appalling. What's your opinion on that?
Well, you know, that's the weighing that the court has to do in any piece of evidence: probative value versus prejudicial value. How much more prejudicial could this be? It's horrible, but the fact is, it is overwhelmingly probative. We're talking about a murder, and the body, and the cause of death, and the mutilation of the body after death. That's what happened. It will never outweigh the probative value, as prejudicial as it is.
And the fire did, according to the opening statement by the prosecutor, affect the fact that they did not find any DNA in terms of semen or any other evidence in the case. So we are going to be returning to the trial. Again, this is Iowa versus Stanley Liggins, accused of murdering and sexual assault, kidnapping, arson of a child. We are going to return to a break at this time, and then we'll return to the trial after our short break. Please stay with us. Well, regrettably, I am going to have to sign off Michael Bryant. He is an incredible trial attorney, an amazing guest today. Thank you for being here with us today.
Pleasure. Happy to do it.
We have enjoyed having you. And we are going to return to the courtroom, Iowa versus Stanley Liggins. And again, this is the witness who is reading a transcript of the arson investigator in the case.